1 o'clock. So we are gonna get this up and running and underway. I am going to share my screen because I did actually put together some materials. I can figure out where share screen is. They moved all of the icons around.
Well, and to buy a
Oh,
moment
there
or
it
two, I
is.
just want to thank everybody for attending today. We have a very impactful, update on all the legislative changes that have taken effect over the last session. And Angela, with Vermont Apartment Owners Association, I want to thank you again for all that you do for property rights and ownership. To everybody who's joining us, please feel free to use, I always get this wrong, the chat for questions.
Q&A,
My
Q&A.
Q&A, sorry, I knew I was going to get it wrong, but you knew
It's all
that with
right.
me.
I
I'm
mean,
Brian
it's fine.
Armstrong, operating principal of Keller Williams, Vermont, as well as operating principal of Strongwell Property Management. And there's so much going on right now in the legislative work, locally and statewide. I know we're going to focus on the state, but there's going to be some interesting stuff maybe we can touch on federally that people should be prepared to advocate for. Please ask questions, folks. The more questions you ask, the better we can bring you guys value. And Angela, I know you put a lot into today and saved me a lot of reading. So I'm hopefully you can help me
Yeah.
understand how I can be a better property owner,
Okay.
better build my wealth, and also be a great member of the community.
All right. Sounds like a plan. So what I did was I took the presentation that I put together for our January meeting. So that was just when the legislative session was getting started, and there were a bunch of bills that I had identified in there. So there's not only an update on what happened with those bills, but then we walk through the ones that actually were passed in this legislative session. So I did leave in here on the agenda termination notices. If we have time at the end, I'm going to run down that one again. You're going to continue to hear me talk about termination notices because it is so important if you're trying to evict a tenant to get those right. This is like the #1 delay for eviction cases, is having a notice that does not comply. And there have been a lot of changes over the last 4 years regarding notices and what's required. All right, so let's jump right in for a legislative update. So just as a reminder, we just ended a biennium. So what this means is that any legislation in the next session has to be reintroduced. So our legislature works on a 2-year cycle. And so any bills that are not passed during that 2-year cycle then have to be reintroduced to be considered again. So we're basically starting fresh, clean slate for this next year in 2025, if we can believe that already. So what I'm going to start with actually is the budget adjustment bill, which is maybe a weird bill to start with, but this budget adjustment provided a bunch of funding for some programs that actually were approved in the 2023 session. So there were 3 different programs that relate for landlord, tenant, and rental properties that were passed in 2023, but the funding for them were not passed. So that funding finally caught up. And so now I think we're going to see the development of these particular programs. And those programs were the rental assistance program. So there's going to be more rental assistance coming in for the state for tenants and landlords to access. There was funding provided for a tenant representation pilot, and I'll dig into each of
Interesting.
these in more detail after this slide. And then there was funding for what's called the rental housing stabilization services, which I'm not still entirely sure what that's going to look like over at CVOEO, but I can at least give folks the legislative framework of what they intended these programs to look like. So this rental assistance program is going to be over with Vermont State Housing Authority, so similar to the RHSP and VRAP rental assistance programs. The goal of it is to prevent evictions for non-payment of rent. I mean, we knew prior to COVID that 70 to 80% of evictions in Vermont were for unpaid rent. We had a period where non-payment evictions dropped off and no cause sort of took its place. And now we're back to what I would consider substantially non-payment of rent situations, which I think, is maybe a different conversation, a different narrative of why so many folks don't have the ability to pay their rent. I think anecdotally, a huge number of those non-payment cases are coming out of subsidized property and our nonprofit housing providers. So there are tenants who are already income sensitized for their rent, which is sort of interesting, concerning, maybe warrants more of a conversation. So there will be eligibility guidelines for tenants. We don't know what those are yet because Vermont State Housing Authority was basically tasked with creating this program and determining what those eligibility guidelines are. This
I'm gonna
will,
guess. Sorry to interrupt. I'm gonna guess they haven't given us a time frame
no,
other than as soon as we can.
right,
That's
right.
not a dig. It's just yeah, excellent.
No, I mean, yeah. Um, this will require sustainability. So this is going to look like the HOP grants that are given out currently for tenants. So there'll be some budgeting and some look at the tenant's income to ensure that they have the ability to pay rent going forward. So this isn't a program where rental arrearages are going to be paid off just for the tenant to fall behind again because they can't afford to live where they are. So the tenant's going to have to show the ability to make payments on rent going forward in order to qualify for the program. This program will cover rent owed, court costs, and attorney's fees. So it'll look a lot like VRAP and RHSP in that regard. So that if a court case is filed, the landlord will be made whole. With that, yeah, it's going to be first come, first served, and basically until the funds run out. So, some of that's going to depend on when the program gets up and running and how many people apply and are approved, and then also how big the delinquencies are. So unlike HOP grants, this isn't going to have a 3-month restriction for rental assistance. This would pay the back rent.
Do you happen to know, and if I'm asking too many questions, you can just ignore me, but
Yeah.
not as a co-host. Do you know how much was allocated for this?
I probably had that somewhere. I don't remember right off the top of my head. But I can find that number. I want to say it was $1 million to
Mhm.
2 million,
Excellent.
but I could be wrong. Don't quote me on that, but it was not a small amount of money. But I think it'll go faster than people think. So there's the thing about this program is that if a tenant applies in for funds for this program, there's going to be a standardized form notification that goes out to the landlord and potentially to the court if there's a pending eviction. And while the tenant has applied for funds and is going through that application process, any eviction cases sort of are stayed. But there's a very quick processing turnaround for these. It's 30 days or less. So it's not a huge delay for court process. But if the landlord, if there's an approval and funds are coming, the landlord's not allowed to issue new termination notices or serve a new summons and complaint on the tenant. Again, that's what the statute says. How those rules are developed and sort of the nuts and bolts, we will have to see. We don't have that information yet. And are there going to be outs for landlords for saying I don't want to participate or I don't want to take funds? That can get tricky if you're trying to evict the tenant for non-payment of rent. Now, if you're evicting for non-payment of rent and some other reason, that could be a justification for not taking the funds, to not stop that eviction. But again, we'll have to see what those rules say. And there may be a period where we're all learning again how to navigate through these new programs and systems. All right, so the next one that was funded was this tenant representation project. So this was a 2-year program, but it was scheduled to start in 2023. and run through 2025. So I don't know what they're going to do with the adjustment of those dates because it didn't get funding until this year, 2024. So we're a year into when the program was already supposed to be running. It is going to be full representation to eligible and consenting tenants. So the tenant has to say, yes, I want a free lawyer, which I think as we find, most of them do say yes. It's going to be in Lamoille and Windsor County only. Yep, the pilot. And it's generally going to come after the service of a summons and complaint. So I understand that legal aid would be reaching out to these tenants saying we can offer you, representation in your case. They have their own mode for how they do that. I think they'd also have attorneys at the courthouse on like rent escrow days or possibly for status conferences and things like that in those two counties. So they'd be very accessible. And I would also guess that the court would be giving out that information about the pilot project for folks to contact legal aid if the tenant's in one of those two counties. Legal aid's going to have to do some reporting. So we'll be able to see, how many folks they're representing, what the outcomes of those cases are. So, how many are getting solved through that rental arrearage assistance fund that was a part of this package, how many are getting resolved through a mediation program, and then how many have been referred to other services for that rental housing stabilization program. So that's the one that CVOEO is going to be running. So there's going to be some tracking of data to just see like how are we connecting tenants with services? Are they getting help that they need? Does it smooth out the relationship? How can we better, address making sure that this process and this relationship runs smoothly for both parties. And a lot of times that comes with connecting tenants with services to get some help. So our rental housing stabilization service, this is the program that's going to be run through CVOEO. It's not specific just to tenants. So it's something that landlords could call. And I think, what it's intended to be is sort of a clearinghouse of resources for both landlords and tenants. A lot of this is what, the Landlords Association does for landlords already. But, this is another option. So they'll have information about the repair funds that are available for landlords, the rent arrearage assistance fund that we talked about, the housing opportunity grants. So those are the HOP grants that folks are familiar with now. Those are what currently offer rental assistance, rental arrearage assistance through the capstone programs and like NECA and SEFCA and all of those community organizations. It's going to have information on the VHIP, which is the Vermont Housing Improvement Investment Program. They changed it, and I can't remember which one they changed it to. It's either investment or improvement. But that's money for landlords. I know that's money for landlords to rehab units. They'll have information about tenant-based subsidies and like where to refer tenants to get put in applications for Section 8 vouchers. They'll have information about existing economic services programs. So, programs that DCF runs. This could be beyond just rental assistance. This could be things for like heating assistance or meals or, other programs that they could take advantage of. They would provide referrals to Vermont Legal Aid, to the mediation program, for different housing education and skills building. So CVOEO will have a component of that for tenants, and then sort of any other housing resources that are created out there. So again, this is kind of like a pilot program. Again, like if we're connecting people with different resources, are they going to be more successful than not? So that's sort of what happened with those two over the last 2 years. Took 2 years to get there. Programs in year one, funding in year two. All right. So in yeah, go ahead.
Go ahead, please.
No,
I was just going to say a comment and opinion. I'm glad actually they went through this. I'm interested to see what happens with the 2-year factor when it started. But my guess is some of the agents and or property owners on here, this would be a great resource to get to our tenants if we start to evict them. Initially, I
Mhm.
was always nervous if they started talking with legal aid, but I also found that if they had an attorney or a legal aid representative that knew the regs, it was
Yeah.
more is more predictable.
Yeah. It can be. I mean, it's definitely not always the case, and I'm sure for, every success story, there's a story that it
Mhm.
was not more successful. But I think generally, both parties having access to legal assistance makes processes run more smoothly. It's a general, there's always exceptions to that, but as a general rule, that seems to be the case. So back in January, I told folks about some different bills. So we'll start with the Senate bill that we were discussing. This was the one that was actually potentially going to be helpful to landlords. So this was changing the definition of actual notice to include email delivery. So that bill did not pass. So nothing happened with it, but doesn't mean that it couldn't get reintroduced or considered in some other formats, which I'll talk about in a little bit. We had a whole series of House bills that were on the list that people were quite concerned about. And, I think the thing to note here is that none of those bills passed, and none of them actually really even made it out of committee. So just because a bill is introduced doesn't mean that it's going to get traction or that it's going to go anywhere. It creates a possibility, but it's not a done deal if something is introduced in the legislature. There's still considerable process that we all have that has to be followed to get to sort of the bill passage. So, what did pass this last year in 2024? Well, let's start over in the Senate. And I'm going to actually briefly talk about one that went through in 2023 because it may have been missed by some folks. So this was S100 Act 47. And it was just at the end of this bill, there was some legislation tacked on related to lead paint. Um, and what it did was remove the requirement for insurance if you're performing work on your own buildings. So there was an update to the lead law. There was combining the federal and state requirements. There was new licensure that happened that is required for lead work. And there was just a blanket, in order to have a license, you have to have insurance. Well, what people discovered was that if you were doing work on your own building, which required a license, you couldn't get insurance because you're not in the business of doing lead work, because you're not doing lead work for hire. And so there was a compliance issue related to that. And so that was fixed in 2023. So if you're doing work on your own building, you no longer have to meet that insurance requirement for licensure. All right, here's an interesting one that got sort of snuck in. And this is, I think, what I found happened a lot this year is there were a lot of little housing pieces that were like tucked in places. This was a big criminal justice reform bill. So S58, Act 125, there was a lot of press about this bill, but hidden in amongst this, which related to charging and age of charging folks if for certain drug offenses and gun offenses, um, was this little provision that relates to a person who's been arrested for dispensing or selling a regulated drug from a dwelling that they are not a legal tenant of. The state's attorney can add a condition of release that prohibits them from coming within a fixed distance of that dwelling.
Interesting.
So if you have that situation where your tenant has invited folks in who are dealing drugs, and those folks who have been invited in are dealing drugs out of the unit and they get arrested, the state's attorney can ask for a condition of release that that person is not allowed to come back to that unit. Because this has been an ongoing problem. And so this is a fix. How frequently it's going to get used, I don't know. It's definitely within the purview of the state's attorney to ask for it and the criminal court judge to issue it as a condition. But it's now out there as another tool in the toolbox for dealing with this, the drug situation and the drug challenges that come to that landlords end up dealing with. It's not going to solve that issue for your actual tenant. You still would have to go through an eviction process for that person. But it, provides a pathway for prohibiting other folks who have been staying in that unit from coming back if they're charged. So,
This is a huge one. I mean, a huge, I don't think we deal with a ton, but thanks to Dan, he's dealing with more of the buildings that I own. But I remember hands-on dealing with tenants' complaints of short-term traffic and all that stuff. And I'm going to guess anybody listening, if they unfortunately have that situation, they probably want to ask the prosecuting attorney and the law enforcement agencies involved to request this as part of any court proceedings. Because when I get called from tenants, or excuse me, clients of KW or property management, one of the first things I'm asking is, how long has the person been there? And I'm seeking out, do they have any grounds to claim Tennessee?
right,
And this is,
right,
yeah, I hadn't heard
right.
this. This is good news.
Yeah, well, it was tucked in that criminal justice bill. I kept waiting for it to get stripped out, right? Like it was one of those things where you're like, is this piece going to go through? Like somebody's going to notice that that's there and squawk about it and it's going to get removed so the bigger bill can go through. Nothing. They were so focused, I think, on everything else that was in that bill related to criminal justice that this little piece just kind of just wrote itself right through. But I think, as you noted, that there are some significant implications there for having a tool to assist landlords who are dealing with this situation with drug dealing out of their buildings. If it's happening by somebody who doesn't live there, they have to get arrested and charged for that. But it's not something that could be done prior to this law going into effect. So will be interesting to see how that plays out for sure. All right, so moving over to the House bills, there was really just one giant bill that was passed that relates to housing. It was like the development and housing bill. This is basically referred to as the Act 250 bill. So yes, there was a ton of stuff about Act 250 and development and trying to make it easier for development. I'm not going to get into all of that. This is like the 171-page bill. There's a lot of resources. Actually, the Peter Tucker has a great summary up on the realtors page of sort of the big highlights of this particular bill as it relates to development and real estate. So that's a good resource for folks to take a look at. I'm going to cover sort of the sections that relate specifically to landlord tenant relationship and situation. So one of the components here was a flood disclosure, which I think, given what we've seen happening the last couple of years, is probably not a surprise. This particular disclosure is a very pared down version of what they started with. So the one that was initially introduced as sort of a standalone disclosure bill had all kinds of criteria. Were you on the FEMA map? Had the property flooded since you owned it? Had it ever flooded in its entire existence since the beginning of time? There was a whole laundry list. And, I think the legislature, to its credit, heard the testimony, which was like, look, we have properties in the state that are 200-300 years old. You're going to have somebody attest that it's never flooded during 200 or 300 years. Like they're not going to know that. They may not even know if it flooded from the prior ownership if that wasn't disclosed to them. so, you got to focus it on what that person knows or readily accessible information. And so what the legislature landed on for the rental disclosure is if the property in whole or part is in a federal emergency management agency mapped special flood hazard area. So these are the mapped zones that are known, and it requires you to do that disclosure at lease signing time. So similar to the lead paint disclosure, if you have a building that's built before 1978.
Mhm.
And it also requires the Department of Housing and Community Development to create a form for people to use for this. So I know they're working on it. It's not available yet, but it will be coming. And I suspect it's going to be pretty straightforward and just follow what the statute requires, which is this is in a federal emergency FEMA mapped special flood hazard area, yes, no, and then sign. Like, it's not going to be overly complicated. So this is something you're going to have to understand about your property, where it falls on those maps. And it doesn't even require, the statute doesn't require disclosure of whether you've had flooding at your property or not. When you've
I
owned
was
it,
just
just whether you appear on
about
that
to ask,
map or not. That's it. So yeah,
which is interesting because we all know that so many of the properties affected were not in FEMA flood zones.
yeah,
I'm glad they didn't include the whole history of the property from the dawn of time,
yeah.
but you would have thought they would have included, has your property ever been flooded? Yes or no?
Right, since you've owned it, right? Like,
Yeah.
yeah, right. So that was not included. Now, whether DHCD is going to develop a form that has that in it, it's beyond the scope of the statute. So I don't know that we would see them add questions that weren't specifically, they were not specifically directed to have that information. But we'll see. As soon as I know that that form's been developed, we'll get it out on the Landlords Association
Mhm.
website. I'll try to send an email out to the mailing list about it, just so people know it's available and out there. All right, so what next? There were some changes to the landlord certificate. Uh, Nothing too earth-shattering. I just set up a reporting system for folks who have ADU units. So I think the state's I think it's a reminder that if you have an ADU unit, you still need to give your tenant a landlord certificate. Um, but the state's also trying to, I think, collect some data related to how many ADU units there are. And so there's some different questions for that particular type of rental versus like the standard rentals. So uh, look for that. I would suspect the Department of Taxes will have that form available for the next tax season. The Manufactured Home Improvement Repair Program, the VHER program, got some more money. So if folks on here own mobile home parks or work with folks who rent in mobile home parks, this is uh, a grant program for both mobile home owners and park owners. So if there's work that needs to be done within the park, so if you've seen a lot of activity in mobile home parks in your area recently, this program is why. It's why roads are getting upgraded and paved. It's why septic systems and water systems in the parks are getting redone. For park owners, it provides some funding to lay new slabs if they're putting in new homes, and upgrade the utility lines that are running to those homes. For mobile home owners themselves, there's grant funds available for them to upgrade if they have oil tank issues, if they have repair work that needs to be done in their home to allow them to stay and live in the home. So it's similar to the VHIP program, but this is for mobile home parks and both the owners of the park and the mobile home owners that rent in parks. So that program got some more money. Also tucked into this bill is a rent payment reporting report. And yes, that's actually how that section was titled in the bill. I know, right?
Don't say
Uh,
it 5 times fast.
right? Exactly. That's lots of tongue twisters in here. So the treasurer's office was tasked with studying whether or not the state should create a program for housing providers to report tenant rent payments to consumer credit reports. So the state treasury office is going to be looking into what entities currently facilitate landlord credit reporting. There's not a huge number of them, is my understanding. They are going to be trying to determine the number of landlords in Vermont that use some sort of rent payment software, what that software costs, you know, do any of those software programs report to credit bureaus for rent payments, the impact of on tenants of rent payment reporting programs, what would be required for the state to do this type of program. So the Treasury office is currently creating a survey. So you may see that come out from the
Mhm.
Landlords Association when it's ready, asking for information from Vermont landlords. So they're trying, this is why. So they've been tasked with creating this report to see if Vermont's going to pursue rent payments. Now, a lot of the focus on this is for positive rent payments. So, you know, if tenants are renting and paying their rent on time,
Mhm.
should they not get credit on a credit report for those? The flip side is that you have to report both good and bad. So it equally
Mhm.
means that tenants who aren't paying on time are going to also have that show on a credit report if a program like this is developed and launched. So this is just study phase and information gathering. So if
Think
you,
it's done in
yeah,
any other states, or is this what this
I
interesting?
don't think so. Um, the credit reporting is very federally driven, federally rules driven. And so I don't know.
Yeah.
I'm having a hard time wrapping my head around how Vermont could accomplish this, but hey, if they're gonna study it and see if it's possible, um, that could be a thing. So I raise it because if you get something from the treasurer's office about this, it's not a scam. It's not, you know, this is why, and this is why they're looking for this information. So does it mean you have to participate? Nope. But just more of sort of flagging it as it's a legitimate request for information related to this bill and sort of what the state's looking at in terms of the information that's being gathered.
And I encourage everybody to advocate for what their personal perspective of. When I first heard he said this, at first I was really excited. I was like, this is a great way that we could actually use credit reports more effectively, not only to acknowledge the good payers,
Hmm.
but to have, you know, not to have to dig so far to find if we have a great tenant or a well-intended human whose flaws accentuate their humanity.
Right,
You know, on the flip side, when I think of all the federal, and we've got a question in just a second. Thank you, Rosie. When you think of all the federal reporting, I would personally have concern that a lot of our members may or may not have the systems to effectively do it. If it was opt in, great.
right,
But if it's required, then I think there's going to be concerns about additional liability to the landlord. So, encourage
right.
everybody to participate, put your thoughts down. At first, I was psyched. Now I'm a little nervous about it.
Well,
Um,
and I think we're very far removed from even being there. This is really just an information gathering endeavor at this point to just find the lay of the land as it relates to uh, all of the moving pieces. And I think, you know, you've identified some of the big ones, right? You know, how uh, ensuring that the data is good if you're going to run a program
Mhm.
like this, that there have to be procedures in place for disputes and saying that the data that was provided is wrong. And, there's a reason why there's a lot of federal regulations around
Absolutely.
credit reporting, and who can report and how you report. And even in those systems, information gets messed up, and it becomes
Absolutely.
very hard to get it untangled if it is messed up. So,
We have
um,
a question. You may or may not know the answer to it yet. Thank you very much, Kelly, for the question, by the way. Is there a limit to the number of rentals you have? Like if you have 5 rentals, are you not subject to it? But if you have more than 10, have you heard? I know you just said they're studying it now. Have
for
you heard
the
any?
for the rent payment reporting,
Yes.
I've no idea. No, I
Yep.
mean the only thing that was in the legislation was tasking the state treasury office to study this situation. So, I think anything related to, is it mandatory? Is it not mandatory? Is it for people with 5 or more units? Does it apply to all rentals? Is a ways out. Um, and they're more at what's out there currently. Do we need something? And then if the answer is yes, we need something, then there'll be the whole development of the program,
Mhm.
which would probably start with some statutorily enabling language, that would give parameters, and then whichever department that program lived with would then develop the program, issue regulations, which is more defining sort of those nuts
Mhm.
and bolts. So it would be a ways down the road, for sure. But I raise it just because I'm anticipating a series of surveys being sent out to folks through different avenues. And I know if I get something that's like, fill out this survey, and I'm not aware of the reason behind it, my inclination is just to delete, like, oh yeah, you're not going to steal my information.
Mhm.
So it's more flagging it. So if you see it, it's probably legitimate, and related to this legislation. So
It's probably an underlining theme. We just all have to be more vocal about our investments. What can we do to be responsible citizens and protect them and advocate? And I think it's going to be very ever, present in the next election nationally as well.
yeah, absolutely. And so the last piece here, that was a part of this bill, I probably could have done like 2 or 3 slides just on this piece, but I figured it would make more sense, for me just to talk through some of these issues. So the final thing in this giant bill was creating a landlord tenant law study committee. So remember that whole list of bills related to landlord
Mhm.
tenant relationship, those didn't move because this study committee was being created. So this kind of got tapped earlier on, and that appeared to be the way the legislature was going to go for these landlord tenant um, issues and situations. So the study committee has been tasked with reviewing and considering modernizing landlord tenant laws and eviction processes in Vermont. So this is potentially going to be a wholesale look at the entire relationship between these two parties. There's going to be a number of folks on this committee. So there'll be 2 members from the House of Representatives, 2 members from the Senate, a representative from Vermont Legal Aid, someone from my organization, which realistically will be me,
Thank
because
you.
that's what I get to do. Somebody from Department of Housing and Community Development, uh, someone from the judiciary, and a tenant who has gone through an eviction, who's going to be appointed by CVOAO. That's actually what the statute says. So um, that's the list of folks that are going to sit on this uh, committee. And so what is the committee going to be looking at? Whether we need to modernize our landlord tenant laws. So, that could be things like how we send notices to people, getting email communication added. It could be as simple as that, right? Like that's a modernization, or text messages. Looking at what the impact of eviction policies are on rental housing availability. So are people removing units from the rental market because of how long evictions take and sort of what the financial fallout is from evictions? And does it deter people from creating units
Mhm.
in the state? The committee is tasked with looking at current termination notices, the periods under those notices. Are they working, not working? Do they need to be adjusted? The eviction processing timeline, so how long it takes for a case to go through an eviction process. Is that an appropriate balance between landlord and tenant interests? What are obstacles to removing unlawful occupants? So this gets into a conversation about, I think, trespass orders and the ability to not have people prevented from coming onto your property after you've gone through some of these processes. Whether the current existing grounds for eviction are being utilized or being properly utilized, or do they need to be adjusted or updated? And what's specifically mentioned is the shorter notice period for criminal activity, illegal drug activity, or acts of violence. So the committee is going to be tasked with looking at, is that notice getting used? And if it's not, why is it not? And there's, like everything, apparently a report due December 15th. So we have a lot to study and go over and not a huge amount of time. So saddle up.
Yeah,
Uh,
you're probably skipping ahead. Anything you can do to share who we should be communicating with, help you, because I know, with a little bit
yeah,
of humor, I thought we might have a little bit of a light topic today, but you have clearly proven me wrong, as I'm wrong every day.
I,
You know,
yeah. So I think the answer to that is I don't know. I have not even received formal communications or informations about the study committee for my association. So I'm not sure who else is being appointed to that committee. It's going to have to happen pretty quick though, because I think a first meeting has to be called on or before August 31st. So
I'll volunteer Peter Tucker if they need more people.
does he fit into one of those categories?
Sort of, not entirely.
So I think, I guess be prepared to hear from me, because I may start posing questions to the Landlords Association email list as the study committee starts looking at some of these things as questions are posed. I mean, I definitely am fully aware of some of the issues regarding notices and litigation, because that's what I do with my other hat for my professional job. Uh, but I do not have the corner on the market on this, and other
Mhm.
people have great ideas or thoughts. I can guarantee that our state, unless there is a wholesale change politically, is never going to look like one of those states where you give notice and 30 days later the sheriff comes and puts everybody's stuff out on the sidewalk. So I don't think we're ever going to look like that. But we could look like something different. Um, you know, do we need a housing court? Do we need a court that only handles
Great
landlord
idea.
tenant and foreclosure matters? Do we need a specialized court for this? Would that speed things up? Would it make the process run more smoothly? I think nothing is off the table per se. Like, this is a committee that's supposed to be looking at these issues. Um, so we'll see how that goes.
This is going to be, and cut me off of my finger wagging, everybody, because I know we're probably preaching the choir by the people who are on here, but not only do we need to advocate for what would be fair and just both for both sides of the fence post, but if we don't advocate, those who do not wish to work with us as cooperative as possible will have a heavy hand in that. And then we could
Mm-hmm.
end up having more than 4 to 6 months to evict people.
Mm-hmm.
And to me, the fact that just cause, I saw it wasn't passed or a moratorium wasn't passed, that is huge.
Yeah,
And that's one of our most important tools in providing safe and reasonable housing, not only for ourselves, but for our respected residents.
right. Right. And I think, this study committee is, tasked with looking at this issue and making a recommendation to the court or to the, not to the court, to the legislature. Sorry, this like switching back and forth there. Um, but just because the study committee makes a recommendation doesn't actually mean that the legislature will decide to pursue it. So the last study committee that I sat on um, proposed to the legislature the creation of the housing registry and statewide inspections and sort of trying to centralize and uniformize that process in Vermont. And that's gone nowhere. So just because a study committee comes back and says, hey, we should do it this way, doesn't
Mhm.
mean it's going to get taken up or anything's going to happen with it, or that you can't still go in and, beat it up in the legislature and committee, the sections that you don't like and are opposed to. So, this also gives will give a roadmap for what other folks are thinking and where people want to see this relationship go. But it doesn't mean it's, the end of days if, what comes out of there, that anything's going to happen with it. Um, of course,
Well,
it
I'm hopeful. I
very
know it's not
likely
great
could.
business.
No,
Yeah,
I mean, I'd like to see some positive changes. I mean, I think the system has challenges, and I think the system does not work effectively for either party right now.
I would
And
agree.
I think that there are things that could be done to make it more streamlined, to make it less um, technical and less complicated.
Mhm.
It is such a complicated process right now that even lawyers struggle to navigate the rules. And something's really out of whack when that is happening. So,
I'm very hopeful. No, it's not a business plan, but I think this could be a great springboard.
yeah, absolutely. So, what I say is, keep an eye out for calls for information or feedback. And that's why you may be seeing those from me or other organizations that work with housing providers, because there's going to be a lot of activity this fall with this. Um, and so, that gets us to, what can you do? Like, how can you participate in this? How can you affect change? And so, we have an election coming up in November. Uh, and this is a great time to get to know your candidates. Who's running in your district?
Mhm.
You know, do your research. Don't make assumptions just based on somebody's political designation. Some of our biggest allies down in the legislature have been folks that would surprise you, and that maybe don't have an R after their name. And I think we're starting to see some shifts with some political party affiliations, just sort of across the board. So, get to know your candidate. Like that's the Vermont way to do stuff, is to know the person. Where
Mhm.
do they stand on these issues? Talk to these folks about your challenges. Again, like a lot of this was on that slide in January. Um, you know, why do you increase your rents? What has happened to your expenses? Like, what's your accounts receivable look like? Like, how are your rent situations going? Have you had to deal with damage, right? And what kind of impact does that have when a tenant leaves and the unit's super damaged? That takes a unit offline for a considerable amount of time sometimes.
And we talked a little bit about this in the past, is I think we tend, when we voice our frustrations, to use words that divide parties, divide people, which makes it harder for everybody to come
Yeah,
together. So just as you typed it here, you brought it in. It was, what was your expenses, Brian? What were your challenges? As opposed to me saying that a horrible resident did this to me, did that to me. Because when we
right.
demonize them, they stop listening to us, at least is my experience.
Yep.
Whereas we talk about our challenges, one of the things too, and I'm sure some of our members deal with it, My stepson and I own a 6 unit building. We just got our new property tax bill. We had to raise each unit $100 a month,
Yep.
all 6 units,
Yep.
to just break even with the tax
Yep.
increase. And we had one tenant we've had for 20 years. She's at 950 in a $1,500 apartment because she's just been a phenomenal human being. And then when we look at consumer price index, inflation, our labor costs as a property management company, we've got to raise her rent even more than $100 now because we can't keep up with the pace of all the rising expenses.
Yes. Yes. And I think, the fallout that we're going to see from that property tax increase that the legislature passed is going to be huge. Folks are just starting to get their property tax bills now and are just starting to see what that impact is going to be. And it is going to impact rents directly. And we're going to see another round of rental increases as landlords and housing providers try to figure out how to make ends meet with a gigantic increase. These are all things that impact the relationship. They impact directly the rates at which rents increase. And there seems to be a tone deaf response to this down in the legislature. So, sort of tying into this, know your candidates, who's running, where do they stand, and don't assume. I don't know if folks read 7 Days. I do. I tend to read most of the Vermont publications just because I think it's good to understand what's happening out there. So this was an article that was about a month ago now, and the QR code there will take you directly, or should take you directly to the article in 7 Days.
Works.
Good. But it was written somewhat as a complaint article about Democrat designated candidates getting donations from folks who have traditionally been Republicans in the state and business owners. And the sense seemed to be from those folks was that, look, these are moderate candidates. We need moderate candidates in the state of Vermont. And so they have a D after their name. We've done our research and they fit more with our ideals and what we're looking for than other candidates. So we're giving them money. But they named names in terms of who some of those candidates were, which is why I have included in here. It's also just an interesting read. Both parties, the leadership of both parties were actually complaining about this practice in this article, which I found to be fascinating, just for me. But anyway, it's definitely worth a read. And I think it, is a lot of food for thought about what we're seeing. And again, don't get distracted by that, letter after somebody's name. Know the candidate, understand, where they stand on these positions, because people might surprise you. So.
Well said.
Yes. And I think, we have a little bit of time here to chat about these termination notices. Because I'm going to keep talking about these.
Please.
Forever and ever. Because it's still the number one reason that eviction cases get dismissed by the court. It's having something wrong with your termination notice. So, these are kind of the big areas that I'm still seeing with notices where people are running into problems. So failure to include Violence Against Women Act forms if you have a subsidized tenant. So if you have a tenant that receives a Section 8 subsidy and you send them a termination notice, you have to include these federal Violence Against Women Act forms. This is for any subsidized tenant. So it doesn't matter if it's a mom with kids, if it's a single person, if it's, a family, doesn't matter. You have to include those forms with it. They're about 8 pages long. So it's also, promoting postage costs, increased postage costs, but you can't double side them. And there's 2 different forms that need to go with these notices. they're up on the Landlords Association website in the forms library, and you can find them out on HUD. HUD also has them. So make sure you're including those. Same with any termination notice you're sending to a tenant who receives a housing subsidy. A copy of that notice needs to go to the housing authority. And it needs to go to the housing authority when you send the notice to the tenant. And I would actually recommend following up with the housing authority, whoever the tenant's case manager is, a week or so after you send it, to confirm that it's in the tenant's file. I have seen some situations where the notice was sent to the housing authority. For whatever reason, it hasn't made it into the tenant's file. And then legal aid files a motion to dismiss saying you didn't send the form because it's not in the file there. So, just, some follow-up can save you a lot of aggravation down the way. We're still seeing notices that are too short. So just a reminder, for most properties, the tenant is going to need a 30-day non-payment of rent notice. We're still in that federally prescribed 30-day non-payment of rent notice. There are exceptions to that, but a substantial number of properties in Vermont are going to fall within that 30-day notice requirement for non-payment of rent. The easiest approach is just to send all your notices for non-payment at the 30-day time frame. So, and remember, that's 30 days. And if you're mailing it with at least 3 extra days for mailing, probably want to see it closer to 35 to 40 days because the Postal Service is so unpredictable these days, but it needs to be at least 33 days. If you're hand delivering it, it's a little bit different, but most folks are not hand delivering their notices. I'm still seeing non-payment of rent notices that have things listed in it that are not rent. So non-payment notice can only have rent. Late fees are not rent. Unpaid security deposits is not rent. Utility charges is not rent. Damaged work orders is not rent. All of those things, all those amounts have to be removed from whatever the tenant's account balance is. So the only amount that's in a non-payment notice is rent.
Right.
Yep. I don't see this one as often, but every once in a while, this one, a notice such as this comes through my office. Your non-payment notice has to advise the tenant that they have the right to pay to cure the notice. So just, I know some people don't like it, but that's the law. And if your notice doesn't have it, court's either going to toss it out, or when it lands with an attorney, they're going to tell you to resend it.
And this is, I think, a plug not only for the association, but for using attorneys such as yourself, who's going to dot the I's and cross the T's.
Yep.
People may try to save 150, $200, but in reality, it's probably going to cost them that much or more.
Yeah. I mean, if you send a notice and it's incorrect and then you have to send it again, now you're just that much further behind in the process. So if you're factoring in the cost of that, and particularly if you have a tenant that's not paying the rent, and now you have to send another notice that's 30 days, chances are you're pushed into another at least 2 months of rent with just that notice. So, the cost of not doing it right the first time is huge. So I'm still seeing some issues with these no cause notices. So what has happened is, if you have a written lease that has a specific term in it, so the lease says this lease begins on this date and it ends on this date, and there is no language in the lease that says at the end of the term, this lease automatically renews on a month-to-month basis. Like, that's how specific your lease has to be. If you don't have that language in your lease, you have to treat for sending a no cause termination notice as if you do not have a written lease, which means longer notice timeframes for your tenants. So there are leases out there. The Landlords Association lease has been updated to have that language in it. So if you're not using the most current Landlords Association lease, I would recommend to go get that, pull it down, because it has that language that automatically transitions it to a month to month, which would keep you in that shorter no cause notice time frame. If you are on a written month to month lease, your termination date has to be at the end of a lease term, which for a month to month lease is at the end of the month. If it starts on the 1st and goes to the end of the month. Now, if you have a lease that starts on runs like the 15th to the 15th, your termination date has to be whatever that end of the month is for what the lease says. So for no cause with a written lease, it is no longer that the termination date can be whenever. Has to coincide with the end of the lease term, which is most likely going to be the end of the month. So if you're sending a no cause notice today, August 6th, and it's a 30-day no cause, your termination date is going to be the end of September, because that's the end of the lease date on a month to month. That gives you at least 30 days. So there have been, some changes in how those statutes have been interpreted. And, one could argue that this is perhaps the proper interpretation of what the statute actually says related to how you terminate tenancies. So just, be aware of those.
Devil's in the details.
Absolutely. Absolutely. And this was my last slide, and I see that we're at 2-minute 2:01. So I think we've done pretty good.
Angela, you rocked it. Thank you very much. I'm, looking forward to reviewing these slides and talking with Dan and making sure we implement everything. And everybody in the audience, thank you very much for joining us today. And I can't stress enough, please recommend these to anybody that you know. Angela, you rock. You bring
Thanks.
us value every day. And again, I'm Brian Armstrong with Keller Williams, Strongwell Property Management. Buy more dirt and let's advocate for our profession for two reasons. It's phenomenal community value to provide housing, as well as I think it's one of the great and last vestiges of the American dream.
Yep. And I think there's going to be opportunities for that, certainly between now and the end of the year, and coming up over the next year. So
we have one last question.
Yes.
Thank you very much, Yana. I hope all is well with you, my friend. What if the lease says that lease is only for the term dates in the lease, and that the owner reserves the right to contract with other parties for dates after the end of the lease? Is this okay language?
I mean, it's okay language, but if you still have to send the tenant a notice to terminate their tenancy, and if they don't leave, you still have to go through an eviction process. So and really the problem becomes more with the folks that the landlords contracted with to come in on the heels of this tenant, and whether you have language in your lease that makes the new lease contingent upon the landlord's ability to deliver possession of that unit. I think that's more critical than that language in the existing tenant's lease, because you cannot bypass the process of removing a tenant in Vermont. It's always the same: notice and then to court to enforce.
Yeah, I'd be very hesitant about that. Personally, that's just my opinion. I'm not the attorney. I think it's a great tactic to promote the person leave on time. But my concern, if you execute the second lease, is you'd have a contractual obligation,
right?
And then you'd have a legal battle on two fronts.
Right. Well, unless you have delivery of possession language, which is why the Landlords Association lease has that delivery of possession language, because we've seen it happen where the existing tenant doesn't leave and the landlord has a lease signed with a new person. And if you don't have that contingency in your lease, then you're essentially in breach of contract with the new person coming in. So
I hope we all get vocal, because I'm excited and hopeful, especially as that study goes through and all the things we're looking at, we can start to see a more balanced approach. So thank you everyone for joining us today. I hope it provided value and helps you guys run your operations better. We look forward to the next, seminar, and continue to bring you guys value.
Yep. All right. Thanks everyone. We'll see you in September.
Take care, folks.
All right. Bye.